Did you know that under United States tax law that on certain types of legal recoveries you pay income taxes on amounts that you never actually physically receive? No, I'm not kidding. The 2005 United States Supreme Court ruling Commissioner versus Banks conclusively established that in certain types of lawsuits with contingency fee arrangements, the lawyers or law firm's attorney fee portion of the recovery must be included in the plaintiff's gross income and reported as income on the plaintiff's IRS Form 1040. In other words, a plaintiff may not report the recovery net of attorney fee. Then, under the 2017 Tax Cut and Jobs Act, there was no longer an available corresponding separate deduction for the attorney fee except for certain types of litigation. Prior law allowed attorney fees to be deducted as a miscellaneous itemized deduction. Even then, these deductions had limited usefulness for many taxpayers because various other rules limited the use of these types of deductions. The combination of the Supreme Court ruling and the changes in the tax law is very adverse to plaintiffs. By having to include the attorney fee portion of the recovery in gross income without a corresponding deduction, the result is a substantially higher federal and state income tax burden on the settlement because it can't be written off as an expense. As a result, plaintiffs may end up with much less of a net recovery. Plaintiffs may see 80% or more of the recovery go to taxes and attorney fees, particularly in states with high income taxes. So what are the types of cases impacted? First of all contingency fee cases are affected except for opt-out class actions, Internal Revenue Code Section 104A2 physical injury cases, but not punitive damages associated with them, which are taxable, or the plaintiff's legal fees are capitalized under Internal Revenue Code Section 263. Note that simply structuring the attorney fee or the plaintiff portion does not eliminate the requirement to include the attorney fee in the gross income of the plaintiff, so you've got to pay attention. If this sounds like a case you're involved in, I'd like to share with you a potential solution. It's called a Plaintiff Recovery Trust. What is a Plaintiff Recovery Trust and exactly how does it work? A Plaintiff Recovery Trust is a trust that has been specifically designed to reduce taxes and to increase protection of a litigation claim. It actually owns the plaintiff's claim, receives the settlement award, then pays the legal fees and expenses, and then distributes the proceeds. It pays the same legal fees as would an ordinary plaintiff, and it distributes the remainder to the original plaintiff. In a taxable case, a plaintiff is typically taxed on 1, the amount received by the plaintiff, plus 2, the amount received by the plaintiff's lawyer. When a plaintiff's recovery trust is used, the plaintiff is only taxed on the first amount, i.e. what he or she receives. This avoids the plaintiff double tax. So how much could you actually save? Depending upon where you live and the size of the settlement, in the typical taxable case, the Plaintiff Recovery Trust could increase your net after-tax recovery by 30 to 70% by lowering your taxes. The higher your tax rate, the more you will save. The higher your lawyer's contingency fee, the more you will save. The higher your lawyer's costs, the more you will save. So let's talk about some examples where the Plaintiff Recovery Trust may be an applicable solution. So this may be useful for claims of punitive damages, penalties, and interest, alimony and child support, emotional distress without physical injury, fraud, negligence, breach of contract, interference with property, contract, defamation, libel, privacy violations, professional malpractice, and opt-in class actions. A plaintiff recovery trust, however, is not needed where the recovery is tax-free or legal fees are deductible, such as physical injury claims without punitive damages or interest, claims brought as part of your business, certain discrimination claims, and certain employment claims. In terms of asset protection, the Plaintiff Recovery Trust is legally separate from the plaintiff and administered by a regulated institutional trustee. As a result, creditors who could ordinarily take the litigation claim would often be unable to do so. Through a proprietary network of banks, the trustee we work with also has the capability to deliver up to $125 million in FDIC coverage per plaintiff prior to distribution while maintaining same-day liquidity. Now let's talk about cost. The Plaintiff Recovery Trust costs nothing if there is no recovery. Typically, the cost of the Plaintiff Recovery Trust will be 20% of your tax savings, assuming you're subject to a combined federal and state income tax rate of 40%. Much of the time, plaintiffs using the PRT are subject to a higher tax rate, resulting in a greater tax savings from the use of the PRT. The settlement advisor who you work with may share in 10% of the institutional trustee's fee, with the total fee remaining the same regardless. So let's talk about how it works. You create first of all, you create your PRT arrangement by signing the Plaintiff Recovery Trust creation form. Other than signing, very little action is needed if your lawyer has already filed a complaint on your behalf. An amendment is needed to memorialize that your litigation claim will be pursued by your PRT. Your lawyer will pursue your claim as if he or she normally would, and recover as he or she normally would. If the defendant makes payment, it will make payments to the PRT. If the defendant agrees to a structured settlement, it will enter into a structured settlement arrangement with the PRT. The PRT is designed to work with structured settlements and qualified settlement funds. The PRT will transfer the portion of the recovery necessary to pay your legal fees, legal costs, and the cost of the Plaintiff Recovery Trust. It will then distribute the remainder to you unless the arrangement is for you to receive payments through a structured settlement. You then have to sign the creation form, which automatically modifies your engagement agreement, allowing your lawyer to pursue your litigation claim on behalf of your PRT. Among other things, you agree that your PRT will join you as co-client of your lawyer, and that you consent in any potential conflict of interest that your lawyer incurs as part of that arrangement. Your lawyers are paid the same amount as they would before signing by the charity named in the PRT. You will sign an assignment of claims and recovery that your lawyer can use to prove that your litigation claim is owned by your PRT. Now let's talk about timing. We often speak of the importance of settlement planning or pre-settlement planning, which includes planning well in advance of the settlement. To avoid double tax, you must transfer your claim before finalizing the settlement or award. A conservative approach is the earlier the better. In Jones versus Commissioner, a 1962 case in the Fifth Circuit, the Court of Appeals respected the transfer of a lawsuit claim pursued for 9 years and then transferred 5 months before a court ruled on the claim. What if you have a case that has both taxable and tax-free elements? Well, all elements of the claim should stay together. The Plaintiff Recovery Trust will avoid double tax on the taxable portion and won't affect the rest. The trustee fee does not apply to the tax-free portion. An attorney or law firm can elect to structure their contingency fees through the PRT by any traditional or alternative attorney fee deferral arrangement. In closing, the Plaintiff Recovery Trust is an innovative and helpful solution to a vexing problem for plaintiffs and their attorneys for the types of damages we've discussed. The solution has been vetted by the legal departments of 4 structured settlement annuity issuers and counsel at a prominent national law firm on behalf of the institutional trustee that we work with. If you would like more information, would like to see an analysis of a particular set of parameters to see how much could potentially be saved on your case, please contact me at the number below. Thank you for watching. I'm John Derer. Have a great day.